Hello, I want to tell you about a super important case that is very helpful to real estate investors. It just came down today when I'm recording this, September 27th, 2018. Um, the issue is whether or not a contract is a rental agreement or a purchase agreement, like a land contract, sometimes called a rent to own contract, which, of course, as soon as you say rent and own, you've contradicted yourself in the first title of the document. So don't do that. It's crazy. So this is an amazing case because I don't know the answer to what the law is sometimes, or a lot of times. Nobody does until the court decides it. And we've got conflicting precedent and conflicting facts to evaluate. This case really helps settle whether or not a contract is a lease and whether or not it's a purchase agreement, like a land contract where you're buying something over time, and what your rights are under that. So what it's called on the title doesn't necessarily mean what it is. The court is going to evaluate it based on what's really in the document. So I'm constantly advising clients of that you can't just call it one thing or another and think that it's going to work. The court is going to look past the title of your document and they're going to interpret it according to what it really is and what's really happening based on the terms of it. So the key feature here, the holding, was that this was a purchase agreement. It was not a lease. It was not a rental agreement. Therefore, the seller was not bound by the Landlord-Tenant Act. And that's important because if they were, this property was in terrible condition and they would have been liable for certain warranties that are under the act. So if you're a landlord and you rent a property, it has to be habitable, right, for a person to occupy. It can't be in bad condition. So we're not going to get into that. This was like a buy and fix up type of a property. So it was not habitable. And the seller in the case who won said, look, we're selling you this property. You're going to make payments on it. And if you make those payments and do everything else in the contract, then you're going to own this property and have the equity in it in the future. And you can sell it and you can keep the profit, right? That's typical for buying something on contract, buying it over time with seller financing. That's another term that's going to come into play here. But the buyer, really, truly, that's the right word, the buyer wanted to call it a lease and say, hey, we get certain benefits because it's really a lease no matter what they called it earlier. The Court of Appeals said a lease has several provisions that are key. Number one is that it has a definite length of time. So it starts today, it ends a year from now, or 5 years from now, or it's some other determinable amount of time. It can even be a lifetime, right? So a lease that's based on your life expectancy can be valid because it has a definite term for it, right? It's not speculative, and we have life tables to determine what a life expectancy is. But most leases are 1 year, 3 years, month to month, 5 years, something like that. When the lease ends, that's a key feature. We know it's a lease. The second part of a lease that they focused on was that the right to occupy that property reverts back to the owner at the end of it. So if you've got a document and you're trying to figure out, is it a lease or a purchase? If it goes back to the owner at the end of it, then it's a lease. That's a key feature. Number one, a definite term.
It's 3 o'clock.
Number two is is there a reversion back to the original owner or not? This contract was not a lease because it didn't meet either of those two basic tests, right? So once the court decided it's a contract, it's a purchase, all these other things kind of fell into place. That's how they decided the matter. And there were lots of what we call amicus briefs or friend of the court briefs saying, wait a minute, this is like a predatory practice. This investor that's selling this property is taking advantage of unsophisticated buyers. They don't know what they're doing. These documents are really tough on buyers if they don't do what they're supposed to. Every letter of the document has kind of draconian default provisions, and for policy reasons we ought to throw this out and call it a lease. even though it's not. So the court said, we're not going to balance those policy decisions. We're going to leave that up to the Indiana General Assembly to decide if those things are appropriate. We don't really get there. This was not a lease, so that's the end of all the legal arguments. So I want to give you a few of the key points of why this was not a lease. First of all, not a definite term. Second of all, no reversion back to the original owner. So there's the first layer of it. The second thing was this contract had these different provisions. So they were buying it subject to payments. So they had to make monthly payments. That sounds like a lease, right? But that's not the end of the story. They also had other provisions in it, right? They had to pay for taxes. They had to pay for insurance. They had to make repairs. They got to build equity. So those were all key features that helped the Court of Appeals say this is a contract for purchase. This is like a land contract. It's not a lease. So all those key things were part of it. The buyer can sell it and make a profit. Those are all things that deal with ownership, and the court said we're going to go with those. So if you've got a land contract, you've got some kind of a seller financing deal, make certain that you meet all those tests and it lines up. This contract, this document was very murky. It had a lot of overlapping provisions that could have gone either way, but the court settled it by looking at the number 1 and 2 things I've said. Is there a definite term, and does the property revert back to the owner at the end of it? Everything else, they just decided not to explore that as much, and they looked at these other things that, hey, you do get to sell the property, you do get to keep your profit, you do pay taxes and insurance, you do get the upside of this thing when you finally sell it, so, and you can convey it yourself. So all those key features were things the court looked at. So very big day for seller financing, holding in favor of seller financing, right? Very important case that comes down. Please read the whole thing. Contact us if you got questions. Contact us if you want us to look at your documents and give you an opinion about how to improve them. We can certainly do that. We really look forward to ways to serve you better and help you with your real estate investments. Have a great day. Thank you.